Good afternoon, everyone. My name is Pascal Pichona, and as president of the European Law Institute, it is my privilege and my great pleasure to welcome you all to this unique ELI lunchtime webinar on AI product liability and the ELI's response to the EU Commission's recent public consultation in the field. In line with its aim to improve the quality of European law, understood, of course, in the broadest sense, the European Law Institute, founded in 2011, does not only embark in preparing projects on a large diversity of issues under its three pillars: the rule of law in the 21st century, law and governance for the digital age, and sustainable life and society, but the ELI also produces so-called innovative papers and takes part to EU Commission public consultation when it comes under one of its projects or field of interest. This is exactly what happened with today's subject. First, the ELI adopted, after consultation of all its more than 1,600 members, an innovative paper on product liability prepared by Professor Christian Twigg-Flessner. Then it took part to an EU public consultation on the draft AI Act, which was prepared in particular by ELI's scientific director and then former president of the ELI, taking into account, to some extent, ideas that had been developed in the newly adopted ELI principles for the digital economies, where Professor Christiane Wenderhorst was one of the co-reporters. And finally, ELI's response to the EU Commission's recent public consultation on AI and product liability, which was filed on 10th of January 2022. Needless to say that the ELI response was also submitted for consultation to our members and then adopted formally. It is certainly, it seems to me, an important contribution to the reflection on how the EU should design its reform of the Product Liability Directive in the context of the interaction with AI, and furthermore, how to design a liability regime for the AI. This is why we have the pleasure to have you today, not only for discussion, but also presentations, and some of the drafters of that response, but also key players within the European Commission for those issues are present. And let me present the various panelists we have today. First of all, we have Professor Bernhard Koch from the University of Innsbruck. He's also an ELI council member. He's currently the Dean of Studies of the University Law Faculty. He's a member of the European Group on Tort Law and of the EU Expert Group on Liability for New Technologies, the so-called NTF, and serves also as the academic director of the University of Innsbruck medical law program, where, of course, the EI and product liability may play a role. Then Professor Christiane Wenderhorst from the University of Vienna, the actual scientific director of the European Law Institute, but our immediate past president, since she was president from 2017 to 2021. She is also a founding member of the ELI. And she chairs the Academic Council of the Austrian Academy of Sciences and co-heads the Department of Innovation and Digitalization in Law at the University of Vienna, and of course has also many other responsibilities. Then we have Professor Christian Twigg-Flessner from the University of Warwick. He is also an ELI council member, and he is now Professor of International Commercial Law at the University of Warwick since, I think, 2017. And he is an Associate Academic Fellow of the Honorable Society of the Inner Temple and one of the chief editor of the Journal of Consumer Policy, among other, of course, important functions. Then two members from the European Commission side, Mark Beamish, Legal Policy Officer at the Director General for Internal Market Industry, Entrepreneurship and SMEs, following 10 years as a civil servant in the European Parliament and a year working for the permanent representation of Germany to the EU during the German presidency. Mark is now the legal officer responsible for the Product Liability Directive in the European Commission, so he knows everything about it. And then we have Professor Dirk Staudenmayer, head of the unit contract law at the European Commission, is the head of this unit at the, of course, DG Justice and Consumers. And he also teaches as an honorary professor at the Faculty of Law of Münster and has published widely, in particular, of course, in the areas of European contract, consumer, and IT law. So as you can see, we have today wonderful experts, and I truly look forward listening to all these speakers. But before doing so, let me just remind you 2 points. One, we will have a Q&A session towards the end of this panel, and therefore we need your questions. You can ask us questions, I mean, to the panelists by clicking on the Q&R button, and there you can send your question. And of course, you can also like the question, I think, in order to make it more apparent, and then we will come and have that. And of course, you can continue to eat and drink if you want so, because the camera is not recording you. And even if you would make some noise, I can assure you we won't listen to that, and we won't hear it because you are all muted. So it is now my pleasure to give the floor to Professor Bernhard Koch, who will present and share the rest of this lunchtime. Thank you.
Yes, thank you, Pascal, for your kind introduction. Good afternoon to everybody also from my side. It is truly a pleasure to be able to talk to you at this lunchtime hour. It's a first for me, but I'm very happy to see such a large audience present at the moment. What I will do here is that I will very briefly give an introduction to the European Law Institute's response to the consultation that Pascal mentioned earlier. And I will then pass on the floor to two of my colleagues who have contributed largely to that response paper. As a first some introductory word about the coming into being of this response paper. We were a team of 7 experts, including our current host and president of the European Law Institute, Pascal Pichonnat, then the 2 other speakers that Pascal already presented. And then we had Jean-Sébastien Borghetti from Paris, Piotr Machnikowski from Wrocław, then Teresa Rodriguez de las Heras-Bayel from Madrid, also on the team. The problem that we faced, obviously, was that we had a very little time to produce this. So we had less than 4 weeks from question to output. And this was obviously during a time where we had other commitments as well. But we still managed to produce at least sort of some key points, and we will address those key points in the following. As to the structure of the paper, we essentially followed the model of the questionnaire posed by the European Commission. So, and we introduced this with some general remarks, but then we proceeded first to the Product Liability Directive and then to the specific question of liability for artificial intelligence, which was the second part of the consultation questionnaire. Now, as to sort of the general structure, there are some general observations that need to be made up front. And I would like to start with sort of a statement that seems pretty obvious. Any further steps in legislation, approximation, or harmonization of the laws needs to start with an assessment of the existing laws on civil liability in the broadest sense in the member states. That's obviously goes without saying. But this is particularly relevant here in as much as obviously all member states already do have existing options responding to losses incurred by victims of defective products, not just the harmonized regime that is already in place, but also alongside that one. And all member states have in place some reaction, let's put it this way, to losses incurred through the use of artificial intelligence or implementations of that technology. The question at the end of it obviously is the existing law sufficient and adequate to respond to the needs of the victims in sort of an overall general picture? Also, this starting point, looking at the existing laws in the member states, basically shows whether and to what extent victims now have a chance to get indemnification. And of course, the starting point for that is, do they need indemnification, and do they need indemnification through the tools of civil liability? We need to be wary of the heads of damage that are currently indemnified in the member states and the conditions for that. As you know, some jurisdictions within Europe are very reluctant, for example, to compensate pure economic loss. And there is a very wide diversity when it comes to compensating non-material harm, for example. So any step towards harmonizing liability that touches upon those fields needs to be cautious and take account of the existing laws in order to avoid conflicts and frictions. Also, we think that non-tort law options also need to be considered alongside the classic laws of delict and alternative systems. So obviously, there may be contractual regimes that already provide ample compensation for victims. So there is no imminent need for victims to have a second path towards compensation. There are social security regimes in place, also, and in particular, workmen's compensation regimes, for example. There are patient and medical liability regimes in place, which sort of maneuver alongside tort law and bypass it to some extent. And so all these regimes need to be taken into account in order to determine the need for harmonization and approximation or changes to the existing regime. A follow-up problem to that is that once you start to improve the position of victims of one particular risk, that raises the question of whether they deserve better protection than victims of other risks. So there is a question of equality that pops up, obviously, which also needs to be addressed, and it can be justified, but justifications need to be identified and then spelled out. Furthermore, particularly when it comes to product liability, product safety rules and in general administrative law rules play a significant role in assessing the overall availability of liability. If you, for example, consider jurisdictions which focus on fault liability, fault is linked to human conduct, and human conduct is assessed on the basis of certain standards of care. And the question then is are those standards predefined, for example, by administrative law or not? So the more precisely, for example, requirements are determined ex ante by law, the easier it gets for victims to proceed to reach compensation. And this also extends, for example, to technical requirements. We will most likely hear about the Artificial Intelligence Act in the following, and questions about determining technical standards and things like that. So again, the more those standards are determined, for example, the easier you are on the path towards, let's say, identifying a defect in a product, for example. One final point regarding AI-specific risks, perhaps. We discussed this obviously in the group, and we all agreed that AI-specific risks, which can only occur in the realm of artificial intelligence implementations, should be dealt with separately. This is not predetermining how they should be dealt with, but they are a different breed. So, for example, think about fundamental rights issues in connection with, let's say, recruitment software that turns out to develop into a biased regime, for example. This is a very specific risk leading to very specific losses, and they should not be confused with sort of the classic tort law losses of personal injury, death, or property damage. And in light of that, we should be aware that our response to the product liability questions were drafted on the assumption that the risks covered will not be changed. So we assumed that the product liability regime of the future will not deviate from the existing limitations to bodily injury, death, and property damage, not talking yet about the further restrictions within that group. But we proceeded from the assumption that, for example, the fundamental rights risks will not be addressed by a product liability regime of the future. Obviously, that is open to debate. So to sum it up, we all agree that there is no one-size-fits-all solution. There are a couple of adjustments that we deem necessary in the field of product liability, and Christian Twigg-Flessner will talk about that shortly. And we have some ideas about possible developments in the field of liability for artificial intelligence, and that will then be addressed by Christiane Wendehorst. And so since we follow the structure of the consultation, I would now pass the floor to Christian Twigg-Flessner to talk about our ideas regarding product liability.
Thank you very much, Bernhard. Yes, what I will do in this part of our presentation is to summarize quite briefly how we decided to address the particular questions regarding the reform of the Product Liability Directive. Our starting point is our innovation paper, which was published about a year ago. But we took this opportunity to look at our ideas in the innovation paper again to see how they might be enhanced or modified, having given the matter some further thought. The innovation paper was always intended to start a debate and not necessarily to provide a definitive position. In our response, we have both general aspects regarding the directive as a whole and also quite specific matters, particularly in light of the ever-increasing digitalization. The general matters might be quite self-evident. The directive was drafted in 1985. The drafting style at the time is a very different one from the drafting style which we see today in so many EU measures. So it is obviously going to be essential, first of all, to update the overall drafting style. Directives tend to be much more detailed these days than they were back in 1985, but also to give more thought to aligning key terminology and key concepts with the acquis that has since developed, particularly in the field of consumer law, but not only there, but also in related areas, for example, safety regulation. In 1985, that acquis didn't exist, and therefore there was nothing to align it with. But now that we have a substantial body of European law, clearly alignment and coordination has become much more important. We also continue to argue that the broad approach of the Product Liability Directive, particularly the underlying idea that it should be easy for injured parties to bring a claim and to give parties a potential variety of targets grouped together under the notion of producer, should be maintained. But these questions, these definitions will require reconsideration in light of the 21st century economy. Also, we need to not lose sight of the quite difficult balance between, on the one hand, protecting individuals, protecting victims of defective products, and the desire to foster innovation to get innovative products onto the market. Let me just pick a few points on the specific terms and concepts that we looked at. Starting with the definition of product. Inevitably, we would like to see, first of all, clarification to ensure that goods with digital elements, so the goods incorporating software to function, are properly covered by the directive. This may already be the case, and there may already be national case law effectively taking this view, but for the avoidance of doubt and for greater clarity and coordination, it seems to us that matter needs to be now addressed expressly in the revised text. Perhaps more challenging, however, is the treatment of what we've called standalone digital content or pure digital products, as it has been referred to elsewhere. This is essentially software and other forms of algorithms, in other words, functional digital content. And we think there is a case to be made for extending the notion of product to such standalone, pure digital content to the extent that it is functional. So we wouldn't, for example, wish to extend the notion of product to pure data, because that runs into difficult issues regarding the way we treat information. And we have seen recently that the Court of Justice has made it clear that information is really on a different level to the Product Liability Directive. A novelty in our response compared to the innovation paper is our treatment of refurbished products. These are clearly becoming more and more important, and crucially, with a desire to encourage sustainable living and sustainable consumption, will become even more prevalent. And therefore, refurbished products ought to be included. There's a difference, in our view, between proper refurbishment and simple repairs. Repairs are generally done for a consumer or individual already in possession, already using the product, whereas the idea of refurbishment is to take a second-hand item, get it back up to standard and remarket it. So refurbishment is much closer to production than, for example, simple repair. Secondly, we are looking at the notion of producer one more time, because the idea of producer is based on the way goods were supplied and marketed some 35 years ago. Now, of course, we have, as already mentioned, the additional people like refurbishers, but we also have two other important players who have joined the landscape. First of all, in the case of goods with digital elements, but also those which are purely digital, we have the continuing updates to those digital elements. And so the providers of such updates might also be usefully incorporated in the notion of producer, because they will have much more control sometimes over the actual functionality and indeed safety of the physical element. We are also looking at the role of online marketplaces. There has been a lot of debate around the extent to which online marketplaces should assume primary liability, but we think as a minimum, where such marketplaces make it easy to import goods from outside the EU into the Union, that there is a case to be made for extending the notion of producer to them and to, again, hold them liable as well. When we come to the notion of defect, again, one important consideration is the availability of updates for the digital elements, and these might need to be factored into the way we understand the notion of defect. Updates can increase safety as much as reduce safety, but to the extent that there are updates available which can increase safety, this might need to be taken into account in how we understand the notion of defect. In a similar vein, there's the long-established notion that the key point is when the product was put into circulation may no longer hold true in the digital environment because of the continuing ability to improve performance, to amend performance through updates. A few words on the notion of damage, which is of course limited to personal injury or damage to property, provided it crosses the threshold, provided the property is used for private purposes. This point itself requires reconsideration because the clear demarcation between private and non-private purposes doesn't hold true anymore. The digital economy has made it possible to have many people acting in a much more gray area, if you like, because they may use products for both private and professional purposes. Somebody might, for example, use their mobile phone, their smartphone, purely for conversations with friends and colleagues, but they might also use it as a way of running their online influencing pages on the relevant websites. So this kind of idea that things are neatly divided into private and non-private purposes doesn't make sense anymore, so that needs to be reconsidered. A difficult question, but one that we think merits inclusion in the notion of damage, is damage caused to other digital elements and indeed data belonging to the individual. For instance, the destruction of important data might be a significant factor to include in the notion of damages. With regard to non-pecuniary loss, however, we are maintaining the position that this should not extend to matters such as emotional distress, but only non-pecuniary loss directly resulting from personal injury. I'll come to the most difficult point now, one that undoubtedly will give rise to some discussion later on, the idea of the burden of proof. As you know, the claimant under a product liability claim only has to show that a product was defective and that it caused the injury. But the complexity of goods with digital elements, the interconnectedness in smart setups and so on, creates a much higher challenge for the claimant to actually prove, first of all, defectiveness of a product and also to prove causation. When it comes to, say, complex products or products continuously interacting and interoperating with other products, think about a smart home setup, it can be very, very difficult indeed to pinpoint where exactly a defect is located and therefore which producer, which product should ultimately be regarded as the one responsible. And here, for instance, it might be useful to extend the idea to include or to simply specify that it is sufficient if the consumer can show that the system as a whole was defective, perhaps drawing on the idea of a commercial and technological unit developed in the expert group report, something we can look at more closely if you wish later on in the discussion. On the other hand, when it comes to data, external data causing a malfunction of a system, we think the best way of dealing with this is to make available a new defense for a producer that data which caused a smart system to malfunction, but it was provided externally, should absolve the producer from liability. So we put effectively the onus of establishing that the defect wasn't caused by the system and how the system operated, but by externally supplied data on the producer rather than the claimant. As far as the burden of proof is concerned, this is a really difficult idea. We have discussed whether it seems sensible to follow suit with what the consumer sales regime does and have a reversal of the burden of proof, but we see difficulties with this. In particular, in the context of the product liability regime, reversing the burden of proof can effectively lead to an imposition of a successful claim, because the practical difficulties of proving causation or disproving causation may be very similar for claimant and producer alike. So we consider a more limited situation where the burden might be reversed, in particular where we have combined a reversal of a burden of proof with more specific duties in respect of, for example, logging the performance of the system. And finally, we're looking at defenses, and we think there are some improvements to be made. For instance, with regard to the notion of putting a product into circulation, this needs to be amended or indeed updated to reflect updates. There will undoubtedly be a political discussion surrounding the development risks defense. And we also think that it's necessary to look again at the role of component producers. And we think this ought to be extended, this defense, to producers of digital components. I think I'll stop here because I've already talked far too long, and I'll hand over to Christiane to talk about the AI dimension specifically. Thank you.
Yeah, thank you so much. Given that we want to have some time for discussion, I will try to be brief, really. And it's maybe very useful to remind ourselves up front of the distinctive features of digital ecosystems in general and artificial intelligence in particular. And those distinctive features are complexity, increased autonomy, opacity, increased vulnerability, and also openness. And these distinctive features of digital ecosystems, and in particular artificial intelligence, then lead to some major challenges for the law of liability. And I will just mention three of those main challenges which we highlighted in our report. One of those main challenges is certainly causation, because it is often very difficult to make sure whether a certain harm has in fact been caused by a particular artificial intelligence, or whether it was rather triggered by some other element with that artificial intelligence was interacting. But it's also, and that is closely related to this point, the question, what should be the triggering factor for AI liability? Should the triggering factor of such liability be the identification of a breach of a duty of care, such as a duty to update the AI properly or to have proper human oversight? Or should it be a specific risk of AI? Or should we have a focus on attribution? And finally, another main challenge already mentioned by Bernhard is that those traditional safety risks like personal injury, property damage, may not be that AI specific after all. There are a lot AI specific risks that do not fall within the scope we traditionally assign to tort law. So there are so-called fundamental rights risks, or we called them social risks in a previous paper. So they're about discrimination, manipulation, exploitation, and the like. And then we're talking about recruitment software, credit scoring software, and the like. So these are major challenges, and causation is certainly one of them, and we deal with that in the ELI response paper in some depth. But I will now maybe focus on what could be possible liability regimes. And there the ELI response paper sets out 3 different possibilities, which are of course not exhaustive. It's just to illustrate the kind of range of different options there is. One option is certainly strict liability for risk. So there you would focus on establishing a new ground of liability. You would be looking for gaps in compensation and undercompensation. You would seek to enhance compensation, in particular to make good for problems which a victim may have in proving the requirements of a claim. And it should then probably be applied only with regard to some inherently dangerous systems and with regard to systems posing traditional safety risks. There's also a possibility to focus on presumed breach of a duty of care instead. So that would have the benefit of promoting appropriate conduct, because it would force somebody operating an artificial intelligence system to really comply with each and every duty of care and really to document properly what they have done. So that would promote appropriate conduct. It might establish a new ground of liability, or it might work with existing grounds of liability. And last but not least, there's also vicarious liability. There, the focus would rather be on attribution of effects and on closing what can be called the accountability gap, meaning that somebody operates an artificial intelligence and then shows that they have bought this artificial intelligence system from a recognized provider, have complied with all duties, but then at the end of the day, nobody really takes responsibility for what the artificial intelligence system does. Now that has certain drawbacks, but it has also the benefit that it can be applied across a broad range of contexts, grounds of liability, and types of damage. And it could potentially include those fundamental rights risks, which we see in the context of systems such as recruitment software or credit scoring software. And last but not least, our response paper also dealt with the notion of damage. Now, clearly, the notion of damage, so what can be compensated, depends on the decision you took concerning the regime of liability. So in some cases, damage will be rather traditional, the tort law kind of damage, the personal injury, property damage, and in the other case, it might be a much broader notion. As the response paper doesn't take a definite position as to the proper way to go forward in terms of liability regime, needless to say, we do not give exhaustive guidance as to what should be compensable damage, but there is one point which we would like to make, that is, we should not probably mix too much the existing traditional notions of damage. So new concepts such as immaterial harm that leads to a significant material loss or so are maybe dangerous, and maybe we should rather try to stick within the traditional notions of damage that are out there. So that would be in a nutshell what the response paper has set out in more detail, and with that I will hand over to Bernhard.
Well, so much from our side, and I think we can now proceed to discuss some of the issues, obviously also not necessarily the ones we presented today, with the 2 representatives from the Commission. And I think Dirk is sort of in line to speak.
Thank you very much, Bernhard. First of all, I would like to thank ELI for organizing this event and inviting us, and Pascal for his very nice words of introduction at the very beginning. And even more particularly, I would like to thank ELI for the response to the public consultation. I mean, we have very good experiences with cooperation with ELI and responses to public consultation, going back to the Common European Sales Law and the Digital Contract Directives. So really, this is another example a model of in-depth treatment of tricky and complex questions. And it is also an example of being very balanced. I may be wrong, but I have the impression that perhaps there was no absolute majority in the group of drafters, and therefore you decided to make different options known. So, which is an interesting and very useful concept for us. Thank you very much for this. However, I need to add, and that also on behalf of Mark, basically who will speak after me, that the Commission has not yet taken a policy decision on what we're going to do. We are at the moment at the stage of analyzing the responses to the open public consultation. We've received a lot, and we're very grateful for that. And we are also working on our impact assessment, which will be fed into the relevant process at the beginning of March. So that's at the moment our main focus. We will also in the next months form some political trends and opinions in which direction we're going in order to prepare a decision by the college, but we don't have this political guidance yet. So for me, it's a bit of difficult to make announcements. Actually, it's impossible for me to make announcements, but therefore I would really like to focus on the discussion, which you mentioned very kindly, and I would like to ask a few questions concerning this very interesting participation before passing the floor and later on to Mark about the questions of the PLD. And as we are already rather late in time, I would perhaps try to regroup questions and focus on, Christiane, on your very useful slides before, where you were explaining the three columns, so to speak, of the options for regimes. Perhaps it may be possible if you bring that back, so it could serve as a support for our discussion. So basically, and I would like to ask a few questions on the strict liability and on the proof-related recommendations you have. And perhaps I start with the proof-related recommendations first. So clearly, the difficulty of ascertaining which input triggered a harmful AI output in a causal sense is at the heart of the challenge we are facing. As it was obvious from the public consultation which we put forward, we're considering whether relieving the claimant of the burden of proof, and there are different possibilities of doing this, could help here. So basically, if that was the solution or part of the solution which will be decided, so if there is some provision which puts the burden of proof on the defendant as to how or why the relevant AI system arrived at the output that caused the damage, we would be very interested to hear your opinion, how such a measure could be designed so as to allow member states to assert this as smoothly as possible and without any frictions into their existing law system. That's my first question. My second question, sub-question on the burden of proof related points is, to whom should it apply? There were some references in the ELI opinion are professional users or not, and that brings me to the question, should such a change to the burden of proof rules only apply to defendants who typically have specific knowledge and understanding of the functioning of the relevant AI? And that could be, in order to be consistent with the proposal for the IAC, the provider or the user as defined in the IAC, which is professional users and providers, or should it be more in line with the general approach of tort law, where a liable person can be any person, also a private person? Should it be all on those? And that, well said, refers to the burden of proof related and not to the possible strict liability question. And a last question, if I may, a sub-question on, because it wasn't clear to me, but perhaps you could enlighten me, basically, because the ELI paper speaks about a rebuttable presumption of a breach of an objective duty to care, but there seems to be also some language in there, but that may relate to the PLD part of your opinion, that you think about a reversal of the burden of proof seems to be a kind of far-reaching measure. It's not clear to me, actually, what's the difference between such a reversal of the burden of proof and the recommended presumption of a breach of a duty of care, certainly in terms of results? So these are my questions as to the burden of proof related recommendations, which we found very interesting. And then perhaps also on the strict liability. So you speak about strict liability for certain situations or particular AI, which may be inherently dangerous by their mere use, and where you envisage a strict liability regime. And then you speak also about filling the accountability gap with a possible application of vicarious liability. What would be interesting for us to understand is what are examples of such specific situations or particular AI or machine learning which you would consider inherently dangerous by their mere use. And if you have such a strict liability regime, which you mentioned, what cases should it apply? How would you determine the liable person? And would you consider, what's the insurance aspect in there? Would you consider mandatory insurance, which you raised as a question several times, or only voluntary insurance? So these are my questions. I stick it here because I would like to really have time for the discussion with you. Thank you very much so far.
Christiane, I suppose you should answer directly, or yeah, I think that might be better.
Okay, thank you so much. So I will at least start briefly, and then hopefully colleagues will chip in. So first of all, concerning the difficulties to prove the elements of a claim, there are of course answers to that at various levels. So first of all, the extent of the difficulty evidently depends on the liability regime you opt for. So there are some liability regimes where this difficulty is greater or lesser. So that as a starting point. Also, I would like to point out before I come to alleviations or reversals of the burden of proof that there is this solution which also Christian mentioned and which was developed by the expert group, the one on technological and commercial units. So that may also solve some of the problems. But turning to the question of alleviations or kind of reversals of the burden of proof, I think there are several different mechanisms that could provide that effect. And I have to refer back also to what the expert group set out in their report. So the expert group in their report set out a whole set of criteria which could be used, which member states should use also in their national laws, be it them substantive law, or be it their procedural law, in order to improve the position of the claimant. And I think that was key finding number 26 in our expert report. And so we listed a whole set of different factors which member state courts might wish to take into account when kind of deciding how to alleviate or to what extent to alleviate or even to shift the burden of proof in favor of the claimant. And then I would like to remind us all that the expert group has also put forward some additional mechanisms that should influence or additional criteria, additional factors that should influence the burden of proof. And that was, first of all, logging. So we see logging obligations, for example, now in the proposed Artificial Intelligence Act, and we may see further logging obligations in upcoming legislation. And the other one is non-compliance with harmonized standards. So these are also two additional factors which the expert group put forward. So as to your second question, whether this should apply to only to professional defendants or to public authorities who are defendants, or also to consumers or private parties. We do not deal with that question in the response paper, actually. My personal view, but colleagues may correct me, my personal view would be that it should be restricted to professional users and public authorities. I personally think that it would be overburdening consumers with liability risks and new duties and obligations. We should rather make sure products are safe, so that consumers really can deal with them the way they're used to dealing with consumer products. And I think it would be overburdening consumers if we kind of have such a reversal of the burden of proof and then let the consumer prove, for example, that it has always updated the system and so on and so forth. But that, of course, also depends on in which liability regime we are in. So, and that maybe also links to your other question, what is the difference between a presumed breach of a duty of care and reversal of burden of proof? Reversal of burden of proof is something that can apply to any kind of element that needs to be proved. It can apply to the existence of the defect. It can apply to causation. It can apply to fault. So in each case, you have the problem that you must prove something and that, you know, there is a need maybe for alleviating that burden. Whereas presumption of a particular of breach of a duty of care, that would basically be a specific ground triggering a liability. But of course, there is an overlap, and both, in particular, when reversal of the burden of proof refers to breach of a duty of care, it's basically very, very, very similar, the concepts. So I'm now looking at my notes. Yes, the question, what could be inherently dangerous systems to which a strict liability regime should apply. As a starting point, I think those systems should not be too different from the systems that already now in many member states' legal systems trigger strict liability. So like objects moving with a particular minimum speed and having a particular minimum weight, in particular in public spaces. So for example, the big cleaning robot moving in public spaces. So I think that would be a paradigm example where such strict liability would be appropriate, actually, or could be appropriate also. And would it be in line with existing strict liability regimes? So I'm just checking, have I skipped anything? Or I will pass maybe to
Christian. Yeah, maybe. Thank you very much, Christian. And maybe Christian wants to add something on Dirk's questions, and then we would go to Mark Bemisch so that he has also time to ask some questions, and then on a more general Q&A. Christian, if you want to add something.
Just a couple of observations, really. I think the burden of proof issue is going to be undoubtedly the most challenging aspect of this particular discussion. And as we say in English, there's more than one way to skin a cat, and I think there are multiple ways of trying to grapple this. Now, I think what we were concerned about is a simple, straightforward reversal of the burden of proof, whether that's, you know, it's particularly in the context of digital products and AI. It simply becomes very difficult to justify this, bearing in mind our overall intention to maintain a balanced system, not to put the burden entirely on the producer. So there has to be some kind of halfway house. And I appreciate Dirk's point that if we insert a duty of care, for example, in between proving and reversing the burden, it does create significant limitation. It will depend on how precisely that duty is ultimately phrased and defined. For example, a logging duty may simply require the producer to make available the relevant information, but then leave it to the claimant, the individual, still to work out whether that data tells them enough about whether the AI system, the AI mechanism was defective or not, for example. So that if the duty is phrased in fairly precise and limited terms, it is quite different from simply having a full reversal of the burden of proof. If, on the other hand, we make this a very broad duty and add a duty to explain and a duty to identify unexpected processes, then the whole thing becomes much more like a full reversal of the burden of proof. And then you're right, the distinction is one without a difference. So the real crunch issue there would be, how do we define this new duty of care regarding logging and what to do with that? Thank you.
Thank you very much. Well, there would be, of course, a lot to say also whether the distinction between consumer and businesses should be kept or not. And that probably, Christian, also depends of the regime. If we have a regime of a breach of the objective duty of care, of course, these duties of care may apply or may not apply. The advantage, of course, of having a large range of addressees is that one would have less to make a differentiation between prosumers and professionals and have loopholes in the whole system. And it might be more easy to work with the type of duties of care and the level of care required from a professional and from a, let's say, a mere consumer, than trying to have fixed limitations. But of course, that's my personal view. I think with that, I could give Mark Beamish the floor, if Dirk is fine with that. Sure. And so, Mark, you have the floor.
Okay, thank you very much, Pascal, and thank you very much for the invitation to speak today. And as Dirk said, also very much thank you for contributing to the consultation. It feels a bit late for an introduction, but just to go very back to Bernhard's very opening point about the need to first assess what the state of play is in civil liability systems. I can reassure you, Bernhard, and all, that the Commission does take an evaluate first approach and to policy development. So this, with the product liability system, started a number of years ago, the evaluation in 2018, expert groups. We've had an impact assessment study running for the last year, the public consultation, as you know, targeted stakeholder consultations, interviews, workshops, etc. So what we're trying to do is to gather all of the different views on the subject, and the academic discussion fueled in part by ELI is extremely useful in that. But of course, we're listening to industry stakeholders, to consumer stakeholders too. When it comes to all of this input, we've had nearly 70 position papers, something like 300 responses to the public consultation. So as Dirk said, we're working through those and trying to draw conclusions from where the stakeholders are on these various different issues. But certainly we're very receptive to the need for balance. The PLD is premised, after all, and it says it in its opening recitals, on a fair apportionment of risk between producers and consumers. So that is obviously something that needs to be carefully weighed with every policy option that we're looking at. Perhaps I could also then ask a few questions to help us on our way. I'll limit it because I see that the time is ticking. Perhaps first to stay with the burden of proof question. I think it's right, as Christian says, this will be something, this is a really difficult issue. It's very clear as well that stakeholders have very divergent views on what should happen, and some sort of compromise way forward will need to be found. What we notice from stakeholder input is that also industry stakeholders, I think, recognize that very complex products or complex cases do cause difficulties for claimants in proving liability. For some of them, even they say, look, there should be some action to hold back national courts from easing the burden of proof. That in some instances that has gone too far in the direction of favouring the claimant. Consumer organisations, of course, say the opposite. Some stakeholders say, well, leave it to member states; they can take care of it. So we're looking at all of these things, but bearing in mind what I just said, that some stakeholders also think that the easing the burden of proof can go too far. There does seem to be a case for setting out some clearer rules on what should, when should the burden of proof be eased. Some ideas are mentioned in the ELI response paper, but you may feel that these go without saying anyway, but compliance with safety standards. I'd be interested maybe in knowing if you think that is in any event, so failure to comply with safety standards would already lead to a conclusion that a product is defective, or just a presumption that a product is defective. And whether you think that, as the court has said in a number of cases, that the burden of proof must not be so heavy that it undermines the effectiveness of the directive. Does that suggest, in your view, that where there really are disproportionate difficulties because of the complexity of the product that the producer understands much better than the claimant, that in such cases there could be a presumption of defectiveness? I'd be interested in your view on that. Then, aside from the burden of proof, I just wanted to raise this question of tangible products with digital elements. And I think in your response paper, you talk about digital elements that are necessary for the functioning of a product. I just wondered what your thoughts would be on digital elements that are not necessary for the functioning of the product, but nevertheless do impact its functioning. For example, a control app. So it wouldn't be necessary. You can operate a product, operate your smart oven with the buttons on the machine, but there is this third-party app that allows you to control the oven. How would you deal with the sharing of liability in such cases? And a very last question, although I have many more I would like to ask. When it comes to damage to digital property, Christian, you talked about destruction of important data, I think the words you used just now. One clear example that we have is data held on a storage device, and that the directive could cover economic loss flowing from that damage. Is that what you have in mind as well? Do you have other examples that you think should be counted as property damage? Thanks very much.
Thank you very much, Mark, for these very interesting questions. I will begin with Bernard, especially because he was not able to speak on the burden of proof before, so at least here he might tackle the issue again. And then maybe I will continue with Christian and Christiane very quickly, so that we still have some time for questions from the public, because we got 9 or 10 questions already. Yes, Bernard, sorry.
Okay, well, first of all, my introductory words were never meant to be sort of suggesting that the Commission does not take account of the existing laws. Quite the contrary. I mean, Ernst Kahner and myself have produced one of the reports that you took in advantage of that. But there was more of a justification for our own approach to the whole thing, because we have to be wary of existing differences. And that's exactly also where the burden of proof matter is placed. I mean, the Sanofi-Pasteur case was one of the best examples where the court struggled with the French generosity towards plaintiffs. And that shows inter alia how different the outcome can be on the basis of the same black letter text. And so this is the real challenge, actually. Also the distinction between procedure and subject matter, substantive law questions, because very easy paths towards convincing a court in procedural law may heavily impact upon the outcome of certain cases, obviously, and that will impact upon the burden of proof ultimately at the end of the day. As to the general question, just one final remark to what Björk also asked before. I think the most fundamental question we need to ask ourselves at the beginning, also with respect to the PLD reform, is that there are two different breeds of problems that we're looking at. We're looking at sort of the classic tort problems that are currently addressed by the PLD, personal injury, death, property, and your question relating to data is sort of flows into that. And as Christian will elaborate shortly after me, this is one of the key problems, obviously, whether data is property within the meaning of the PLD. But then there is a different problem set, which is sort of the for recruitment software, things like that, which happen purely digitally and which do not cause losses of the classic kind. And those need to be kept apart for sure. And those losses, we think, should not be falling under the PLD, even under a reform, but should be addressed separately. Because if you were to incorporate them into the PLD regime, this would completely confuse the whole concept. It would be very difficult to keep things apart within the PLD regime. So that's perhaps one of our primary messages, even, that those two problem sets should be kept apart, and that the PLD should limit itself to the classic range of traditional torts. And that leads to what Christiane said earlier about the strict liability questions. To a large extent, strict liabilities will continue to be cases that we already see now as strict liability cases. So objects moving in public space at a high speed with large mass, which cause loss because of that. And the only difference is that instead of a human driver, you now have a machine driver, so to say. So that problem set is entirely different from the modern, novel AI problems of recruitment software leading to biased outcomes and things like that. But I think that Christian can perhaps respond more specifically to the PLD questions that we addressed.
Indeed, Christian.
Thank you. Thanks, Mark, for your questions. I'll be quite selective in my answer just because of time, but we can obviously pick this up another time if that would help. Let me, first of all, the general point about burden of proof and the complexity. I think, as I said before, this is something we will continue to grapple with, and there won't be an ideal solution. There will have to be some kind of workable solution, a compromise, as you suggest. And I think we also mustn't lose sight, and Bernard has touched upon this, and the document makes the point as well, the interaction between the product liability regime specifically and national rules on procedure, and how these deal with evidential matters and so on. And of course, there's quite a bit of variation between the member states as well. On the question of conformity with safety standards and how this should be treated, it's an interesting one, because on the one hand, you might want a definite position. If you don't comply with a safety standard, then there's clearly a breach, the product is defective. I suspect that will depend on the nature of the standard itself. Is it a mandatory standard? Is it a voluntary standard? But I'm sure this is something worth exploring. But of course, to some extent, it sidesteps the issue, because there will still be the difficulty for the consumer, also the claimant, to establish that there was a failure to comply with the safety standard. So we might be back to the same question of how do we actually prove this then? So we're not necessarily getting much further if we focus on that as a significant element. On the question of the inessential digital element, say the controller that you then use to control a device. Clearly, this wouldn't be necessarily a matter where we say this is a good with the digital element, but we would have to look at this inessential but yet very useful control app, in your example, as simply freestanding functional digital content. And we would still regard this as being within the scope of the directive if that digital content, that app, then has the effect of creating the kind of damage which is within the scope of the directive. And again, that's the important point. We are still very much focusing on largely damage to property and or personal injury. But of course, there is the difficult question of how we treat data. There's an unresolvable debate about whether data is property or not, and national laws take different views on this, and we don't want to necessarily open this particular can of worms. But there may be an argument to be made that certain types of data, and perhaps that requires further exploration, do merit inclusion within the things that could be damaged, at least in certain circumstances. But of course, we are not saying elsewhere that data should be part of the notion of product. we discussed this, and there are different views on this, but ultimately I think the approach we've taken is probably the advisable one. Data of whatever kind, which isn't functional digital content, so pure data, is outside the scope of the notion of product in our view. And any questions regarding issues with the data itself might probably be resolved as a matter of contract law. And in this regard, see the ELI principles on the data economy, which offer some very useful pointers. I think I'll stop here just because we are running out of time. I could say a lot more, but Christiana, you wanted to come in as well.
Indeed. Christiana, do you want to add something?
Yes, but extremely brief. So safety standards, I think they come in at 2 points. They come in when it's about determining defect, and there they have a particular role. And they may in the future also come in when it comes to reversing or alleviating a burden of proof concerning causation. And there I think they would fulfill a different role. As to digital elements that are not necessary, that are not digital elements within the meaning of the Consumer Sales Directive or the new Sale of Goods Directive, I would personally favor, and I think that's in line with the response paper, the principle of equivalence of hardware and software. So if you had a tangible tool that controls a different tangible item, you wouldn't have any doubt at all that this is something that falls under the Product Liability Directive. So now, in modern times, this tool comes as a software. Why shouldn't it be included? As to the destruction of digital assets and data, that's a very tricky point, and we also discussed it in different places. I personally would be very, very in favor of including it. I could also imagine, if that sounds like going too far, a certain restriction. For example, 2 cases where the damage results from the damage to a physical medium, or where the purpose of the product in light of its description and the reasonable expectations of the end users included the purpose of keeping that those data and those digital assets safe. So this I could imagine personally as a restriction, but generally speaking, I would be in line with the response paper, be very much in favor of including it.
Thank you very much. So we have still a couple of minutes available, not much, I must say, but the discussion and the questions were already fascinating. I just want to pick up out of the 11 questions we hear here. Some were triggering the fact that there are several potential author or person liable for the use of the AI, and looking at, of course, what we call allocation, attribution, and causation. And there are 2 questions linked to the insurance aspect and also the aspect of social insurance, and to what extent that would be a solution to all these aspects, which is a point that we did not really tackle, I think. So maybe I can give the floor to Bernard to answer or say briefly something about this issue of social insurance or specific insurance in order to avoid the causation difficulty or attribution difficulty.
Yes, first of all, starting with the immediate question of compulsory insurance. Obviously, we didn't address this specifically, but we have a broad experience with compulsory insurance regimes linked to strict liability regimes, for example. And so it wouldn't come as a big surprise that if the Commission were to introduce some sort of strict liability, that would typically be coupled with a mandatory insurance or some sort of backup regime, because otherwise things simply wouldn't work. That is internally linked to the question of whether the insurance industry is ready to cover that risk. Because I've worked on risk scenarios where the insurers claimed they're not willing to subscribe those risks, and so you would have introduced the mandatory insurance regime, but you wouldn't have found an insurer to cover it. So that would be sort of counterintuitive. So that obviously compulsory insurance helps with that, and we have obviously ample experience in the field of motor insurance, where you have a vast and rather well-functioning regime that covers those risks. And as Christiane said earlier today, in those classic cases, for example, motor traffic, it really doesn't matter whether you have a self-driving car or a human-driven car. The first responder is always the insurance. And so the question of liability and which component was flawed is a question that somehow shows up somewhere in the back end of the recourse action. And there are different players on that level, not the immediate victims, but typically professionals, insurers versus producers, who in turn have their own insurers at hand. So that's a different playground where you perhaps need less protection of the individual parties to that process. So obviously insurance does play a role, and Social Security obviously is always the first buffer when it comes to personal injury. And the response of social insurance regimes to seek recourse is also different in the member states, and the motivation to do that is different depending upon the extent of harm, obviously. And so, as I said at the very beginning, all this obviously plays into the overall outcome and needs to be considered in order to underline the need for intervening from a legislative point of view. And then, well, I'll stop there and I'll leave others space to reach.
Maybe I come up with a second question, and then in case we have some more time, we come back on that. There is an interesting question on the difference between product and services that might get blurred by opening up, of course, the notion of product, and a question that is related, which is a product that would be a machine learning system, continuum learning system, says here the question, and it's an open system. So how would it be possible to set up the causal link in a way, or the effectiveness of such system, if maybe when one looks at the system later on, I mean, the defect is no more there because the product continued to evolve. At a certain point of time, it was not perfect, or it was effective later on not. So maybe that's a question for Christian, if you want to answer that type of questions.
Thank you. Yeah, I'll take the first point first, and on the second point, I think Christiana might be able to supplement. But as far as the distinction between goods and services concerned, and where software fits into that, that's again something which has kind of been sidestepped so far, because if you look at, say, the Digital Content Directive, that makes it quite clear we're not getting involved in how we classify this transaction, but we're treating, and this is the crucial point, we're treating the digital content and the digital service in the way we treat goods. In other words, we are imposing the same conformity requirements and so on. So we are effectively already moving towards a situation where, irrespective of how you categorize the underlying contract and supply transaction, we are treating digital products as equivalent to physical products in terms of conformity requirements, and therefore doing the same under product liability seems only logical. And in fact, we are making the point in our paper that the distinction between software in a narrow sense, something you install on your computer, and software as a service is also not relevant to whether or not liability ought to be imposed. The two pretty much ought to be treated in the same way. And this is kind of part of a much wider issue about how we respond to digitalization, and that's so often our established categories and paradigms may just not quite work, and we might have to not get too bogged down in these particular historically arisen distinctions. We might actually have to be a bit more creative in how we respond to these new particular challenges. And on the second point, I'm sure Christiana will fill in on that, but in many ways, if we are saying AI could in principle, for the losses covered by the directive, be included within the notion of product, then I think the same applies to self-learning, machine learning algorithms. The question then comes back down to a question of proof, and whether at the crucial point in time there was a defect. And if we do have things like a logging obligation, for instance, then that might well be identifiable. So I don't see this as necessarily being an insurmountable hurdle, but Christiana, perhaps you would like to supplement.
I fully agree. I fully agree. And just to mention, there's also the question of what is the relevant point in time. And I think that needs to be addressed too in the Product Liability Directive.
Indeed, this is important. And there was also a question, but I think we answered that in the paper, whether there would be a need for two directives, one for the AI liability, one for the product liability. The view of of the ELI or of this response is to say there should be two different directives or let's say instruments, but this remains to be seen, because as we have seen today with the discussion, there are overlaps, there are similarities, but there are also important differences. Given that it's already 1:30 on continental time and 12:30 in England and elsewhere almost, sorry, Christian, we have to come to an end, because of course you will need probably to go back to work, even if we would sit here for another hour very easily. So I would have loved to give all of you, 1 minute for a final say, but maybe I could give to Mark and Dirk, 20 seconds each to say something if they want to, as a kind of pre-conclusion. And maybe I begin with Dirk.
Actually, I wanted to give Mark the first priority because he kindly let me start before. So I think it's polite to let him start, please.
Welcome.
Well, I will only say watch this space. It's been a very interesting discussion, and the discussion will continue. And I look forward to the next event.
I couldn't agree more. Looking forward to a continuing discussion and looking forward to a continuing cooperation with ELI also on other issues, not only on air liability. Thanks a lot for your contribution.
Thank you very much. It's my turn also to thank all the panelists for these very interesting remarks and discussion. Of course, all the attendees to this webinar, and I think they were also very good questions. This will also be put on our website so that things may continue and the discussion should, of course, continue. Thank you for taking the time. Thank you for being here. Thank you also for the Secretariat of the ELI for organizing everything and for being here. I wish you all to stay safe, of course, and to continue to think about these issues, and look forward to meeting you at a next meeting online probably. Thank you very much. Have a good day. Bye-bye.
All right.